yesterday at the Supreme Court, the question of birthright citizenship came up. And that was actually sort of the secondary question. Birthright citizenship, obviously provided by the 14th Amendment, a function of sort of the bedrock, frankly, of the 14th Amendment, the bedrock of the United States as we know it today. This is part of the series of constitutional amendments that followed the Civil War. The 14th Amendment making it clear, really, that the radical Republicans at the time wanted to make sure that we had a multicultural democracy where children of slaves born in the U.S. were considered citizens on par, at least in theory, with all others, and that anyone really in the country at that time who gave birth, their children would be citizens of this country. This has been, I mean, I want to say longstanding, but I mean, really, so what was it, 1866, 1867? Constitutional law in this country. Donald Trump, on his first day of his administration, signed an executive order basically saying that it didn't apply to people who are in this country, who were born in this country, if they were here without documentation, or if they were here just visiting.
Or if you're on visas. I mean, I think that was part of it.
Visiting on a visa.
Oh,
legally
right. Okay,
here.
yeah.
Exactly.
Yeah, right.
And
right.
So the backstory to this is that the administration lost in multiple jurisdictions around the country. And in all of those jurisdictions, the courts, the federal courts, issued a nationwide injunction against the administration using or, you know, deporting or considering people non-citizens as a function of this executive order. And the Trump administration took this case to the Supreme Court to not resolve the question of birthright citizenship, but rather to address the question as to whether these courts had the ability to issue a nationwide injunction based on their findings about that. Instead, what the administration is arguing, it only applies, their ruling should only apply to the single individual who brought the case. And I think it's pretty obvious, like, you know, there are times, and the justices, at least 3 or 4 of them, 4 of them, I would say confidently, made it clear that there are limits to the ability of, let's say, a district court judge to issue a nationwide injunction. But if there's ever a case in which you would see the validity of such a court issuing a nationwide injunction, this one makes the most sense because it's going to impact.
That's basically the argument is that the courts cannot issue injunctions, period, about the administration's actions because their actions don't affect one particular person. I guess in some very narrow instances, if you're pardoning someone, but they don't have any power over that. They're making policy decisions as the executive branch. That's their argument, is that they have no jurisdiction over our actions, which is not true.
Here is, let's start with a couple of clips. Let's start with here's Elena Kagan asking if you weren't ever going to allow, if you don't believe that these lower courts have the ability to issue this injunction on this, why would the government ever come to assess whether birthright citizenship is legal? Because they could go after it and keep going after it and keep going after it. This is number 3.
It sort of depends on the government's own actions. In a case like this one, where one can expect that there is not going to be a great deal of disagreement among the lower courts. I mean, let's assume that you lose in the lower courts pretty uniformly, as you have been losing on this issue, and that you never take this question to us. I mean, I noticed that you didn't take the substantive question to us. You only took the nationwide injunction question to us. I mean, why would you take the substantive question to us? You're losing a bunch of cases, this guy over here, this woman over here, they'll have to be treated as citizens, but nobody else will. Why would you ever take this case to us?
Well, in this particular case, we have deliberately not presented the merits to this court on the question of the scope of remedies, because, of course, that makes it a clean vehicle where the court doesn't have to look at the past.
You're ignoring the import of my question. I'm suggesting that in a case in which the government is losing constantly, there's nobody else who's going to appeal, they're winning, it's up to you to decide whether to take this case to us. If I were in your shoes, there is no way I'd approach the Supreme Court with this case. So you just keep on losing in the lower courts, and what's supposed to happen to prevent that?
Again, I respectfully disagree with that forecast of the merits, but in response to the question, what I would say is, we have an adversarial system, and if the government is not, for example, not respecting circuit precedent on the court's hypothetical in the Second Circuit, someone injured in the Second Circuit could take the case up, and they could say, look, the government is violating circuit precedent on the hypothetical multiple circuits.
That's the case we're going to take? Somebody who says, after we've said that this all has to be done one by one by one, then we're going to take a case from somebody who objects to proceeding one by one by one?
I'm
not. So, I mean, she's basically saying, what's to prevent the government from just keep doing what they're doing? They'll lose a handful of cases on the merits, but that'll only affect those individuals. Not everybody's going to take a case. Who is going to come and take this case up to the Supreme Court? Like the idea that there would be, they're not going to appeal if they win the case. And her hypothetical is all these people win the case. Here's Ketanji Brown Jackson.
Well, I just want to say, just to flesh out what she's saying, because it's important. Like, she's saying you're not, the nature of the case that you're bringing is not looking at the question of birthright citizenship, the substance that is supposed to be being addressed by this. They are going after the usage of nationwide injunctions, which feels like a tangential point to the executive order that Donald Trump issued, which is basically trying to nullify one of the major parts of the 14th Amendment without a constitutional convention, because that would require 2/3 of the states and 2/3 of the legislature to make that kind of overhaul of our Constitution. So there is no substance here. And it's just odd that the lawyers almost recognize that even in their argument, and she's laying it bare for them.
But yeah, she's saying that the reason why you're not, I mean, the problem with the outcome that he wants, which is that these circuit courts cannot do nationwide injunctions based on this question, would mean that the question itself could never get resolved by the courts.
Yep.
Because even if they keep losing these circuit court cases, and each individual, my name is Joe. My parents came from Mexico. They were here on vacation and I was given birth or whatever it is. And so now I get to be a citizen, but the government can continually deny citizenship to a whole host of people. And if each individual has the ability to take a case, eventually they may reconstitute themselves. But the government has no incentive to ever go and actually get the question resolved. And if all these people are winning their cases, there's no appeal to their case to go higher up. And so that is the dilemma that she is talking about in this instance. And here's KBJ, who I think like teases it out more.
Yeah.
the injuries of the plaintiff before them. That is the
I understand. Let me just turn your attention to one other thing, because the real concern, I think, is that your argument seems to turn our justice system, in my view at least, into a catch-me-if-you-can kind of regime from the standpoint of the executive, where everybody has to have a lawyer and file a lawsuit in order for the government to stop violating people's rights. Justice Kagan says, let's assume for the purpose of this that you're wrong about the merits, that the government is not allowed to do this under the Constitution, and yet it seems to me that your argument says we get to keep on doing it until everyone who is potentially harmed by it figures out how to file a lawsuit, hire a lawyer, et cetera. And I don't understand how that is remotely consistent with the rule of law. You know, a system, and I appreciate that you go back to English common law and the Chancery Court, but they had a different system. The fact that courts back in English Chancery couldn't enjoin the king, I think is not analogous or indicative of what courts can do in our system, where the king, quote unquote, the executive, is supposed to be bound by the law. And the court has the power to say what the law is. And so one would think that the court could say, this conduct is unlawful and you have to stop doing it.
I think the catch-me-if-you-can problem operates in the opposite direction, where we have the government racing from jurisdiction to jurisdiction, having to sort of clear the table in order to implement a new policy. A great example of this is in the Schilling litigation, where the military had a military readiness policy. It was universally enjoined by the DDC. It went up to the DC Circuit. The DC Circuit stayed that injunction to allow that policy to go into effect. And then 1 hour later, a district court on the other side of the country universally.
Can I just ask you one final thing, because this relates to also something that Justice Kagan said. I would think we'd want the system to move as quickly as possible to reach the merits of the issue and maybe have this court decide whether or not the government is entitled to do this under the law. Wouldn't having universal injunctions actually facilitate that? It seems to me that when the government is completely enjoined from doing the thing it wants to do, it moves quickly to appeal that, to get it to the Supreme Court, and that's actually what we would want. What I worry about is similar to what Justice Kagan points out, is that if the government is saying no lower court can completely enjoin it, it actually means that the government just keeps on doing the purportedly unlawful thing, and it delays the ability for this court to reach the underlying issue.
Percolation of novel, sensitive constitutional issues is a merit of our system. It is not.
All right, whatever.
Percolation.
That was just really fascinating, because it ties in what I was almost about to say after the first clip, but I'm glad I held my tongue, because this is an even better example of they are trying to get the courts to voluntarily restrict their own power over the executive branch. They were successful with the unitary executive theory, and they're pushing even harder. They tried it with the Kilmar Abrego Garcia case, and the court ruled at 1 a.m., hey, you can't do this. You can't ship off these Venezuelan people here without due process. And they stopped them from doing what they wanted to do unilaterally. So she brings that up, right? That they're attacking the concept of injunctions because they can't attack the merits of the 14th Amendment. And it's also telling that they're using English common law to make this case, because we go back to our conversation with Gil Duran about this whole vision of the king monarchical presidency. That's what they're trying to engender. That's what they're trying to create precedent for, because there's quotes from 2022 from Clarence Thomas when he's been asked about Section 1 of the 14th Amendment, the Citizenship Clause. And he basically has reiterated this. This was in 2022. The addition of a citizenship guarantee thus evidenced an intent to broaden the provision, extending beyond recently freed blacks and incorporating a more general view of equality for Americans. He wrote that in 2022. Now the conservatives are going to try to say that this only should apply to the descendants of freed black slaves, because they're the originalists now. But Thomas understood this in 2022. So I think, like, even the administration knows that on the substance, They can't even call back to like what conservative justices said 5 years ago, 3 years ago, because there's no merit. So they're attacking the court system generally.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.